Welcome once again to Lehto's Law. Here's Steve Lehto.
My inbox has been inundated with emails regarding an opinion recently issued by the Ohio Supreme Court, and it's one of the most absurd things any of us have ever seen, referring to myself and all the people who contact me. Said, Steve, did you see this? This is insanity. Yes, it is. The news is responding as if it is, in fact, insanity, and it is because the Ohio Supreme Court completely missed something that is so painfully obvious that I used to teach law school. I taught law school for 10 years. And if a student had handed this in as their quote-unquote answer to a question I had written, I would flunk them. And that's because they just ruled that boneless chicken can contain bones so long as you can't prove that the person who sold the boneless chicken had been negligent in doing so. And they said, as a matter of law, you can't even find that they were negligent in doing so. And so negligence, or lack thereof, became a defense in a case which was actually a UCC case that has nothing to do with negligence. And so this is kind of complicated, but I think most people will understand it. At least they'll understand it on the level that boneless chicken can't contain bones without something being wrong. The question is, what is wrong with it? So the case is called Berkheimer versus REKM, and it has to do with bones in chicken. So Michael Berkheimer sued a restaurant, its food supplier, and the chicken farm after he's suffered serious medical problems resulting from getting a chicken bone lodged in his throat while he's eating a boneless wing. There's no question that the restaurant called it a boneless wing. The trial court determined that as a matter of law, defendants were not negligent. Oh, okay. Is a lack of negligence a defense to everything? Do you know why I pulled you over? Why? You ran a stop sign. Can you prove I was negligent? No, you ran the stop sign. It doesn't matter whether you're negligent or not. So if they sell something that harms somebody, is a lack of negligence an absolute bar to every possible lawsuit? No, it's not. We'll get there. Berkheimer, the plaintiff, contends that the Court of Appeals focused on the wrong question, because keep in mind the Court of Appeals agrees with us. Whether the bone that injured him was a natural thing for the boneless wing, incorrectly determining a restaurant did not breach a duty of care in serving him the boneless wing. And so here they're talking about this all being a negligence claim. Keep in mind, negligence is where I owe you a duty. I breached that duty and you are harmed. And so you might say, but Steve, serving somebody bad food sounds like it could be negligent. Oh, it could be. It can also be other things. So keep in mind that when I file a lemon law lawsuit, it's often a 7-count complaint. And one of those counts might be negligence, but that's not the only thing we're suing under. And quite frankly, it's a throwaway. If someone said, Steve, your case will get dismissed unless you remove that negligence claim. Oh, yank it. I don't care. There's better things to go under. Trust me. So to give you some background here, Berkheimer had dinner with his wife and a small group of people at Wings on Brookwood, a restaurant in Butler County owned by REKM LLC. He placed his usual order, which was boneless wings. There was no warning on the menu indicating the boneless wings could contain bones. Now, here's the thing. That's irrelevant. They were called boneless wings. If they're going to contain bones, why is the word boneless there? Why not just call them chicken wings or buffalo wings or something? But to call them boneless, the word boneless must mean something. Are you saying boneless is just simply like a nickname or something? In the following days, he had something lodged in his throat. In the following days, he had a fever and was unable to keep food down. 3 days after eating them, he went to an emergency room. In response to his wife's concern, he might have something stuck in his throat, and a doctor discovered a thin chicken bone lodged in his esophagus. It was 5 centimeters long. According to the plaintiff, the bone tore his esophagus, causing a bacterial infection. So they go on and on about all of this stuff that has to do with what happened. Now, here's the key. Berkheimer filed a complaint, which is a lawsuit, against these parties. His complaint alleged claims of negligence, adulterated food, misbranded food, violation of the Ohio Deceptive Trade Practices Act, and breach of warranty. That is the best count here. It's the easiest one to prove, and on these facts, it has been proven. Breach of warranty. Instead, the court focuses entirely on negligence and says because there's no negligence, all the other counts go away, and then they kind of gloss over the warranty. They talk about whether the food was adulterated, and adulterated, of course, means that there's something in the food that shouldn't be there. And they say, of course, well, chicken bones come from chicken wings, so therefore it's not adulterated. They claim it's not misbranded because the restaurant wasn't negligent, and they say it's not deceptive, therefore all this goes out the window. What about that breach of warranty claim? Oh, well, we'll get there because the court spends 14 pages tap dancing around a lack of negligence. So the defendants filed motions for judgment on the pleadings, which the trial court granted. A district court reversed the trial court's judgment, concluding that the facts weren't in all yet. The parties did more discovery, and then the trial court then granted the motions, determining that common sense dictates that the presence of bone fragments in meat dishes is a natural enough occurrence that a consumer should reasonably expect it and guard against it, even dishes advertised as boneless. Now, I'm going to have to ask you again, seriously, why do you call it boneless when you could simply call them chicken wings? Chicken wings. Boneless chicken wings. So if I ask you what's the difference between chicken wings and boneless chicken wings, the Ohio Supreme Court says no difference. There's no difference. Why would there be a difference? So they then posed two propositions of law. One, and this is what they're going to determine, as a matter of law, whether a consumer should reasonably expect, anticipate, and guard against an injurious substance that has specifically been disclaimed by the seller. I don't remember them disclaiming that, and this court should bring Ohio in line with the rest of the country because some other states have said that this can, in fact, be a cause of action. But why don't they address whether or not it's a breach of warranty? Oh, well, yeah, no. Remember, if I can frame the questions, I can win the argument. And if I can ignore questions, I can really win it. So the analysis here says, this is labeled analysis. This is Roman numeral 2, analysis. Plaintiff contends that defendants were negligent in producing, distributing, or serving a boneless wing with a bone in it. In order to establish actionable negligence, one must show the existence of a duty, a breach of the duty, and an injury resulting proximately therefrom. Yes, that is true. That is true if we're just talking about duty and negligence. But what about warranty? Well, they go through this whole explanation about whether or not the parties that sell food are negligent when they have things that are still in the food. And they say, today we reaffirm the rule that we adopted in the previous case to determine whether a supplier of food breached its duty of care, again negligence, by failing to eliminate injurious substance from the food. We look to whether the presence of the substance was something a consumer could have reasonably expected and thus could have guarded against. So it is the person at the restaurant, it's their job to make sure the food is safe, according to this. That's what the court's saying. But worse, they're focusing on negligence, paragraph after paragraph. And then there's a dissent, and the dissent is the other judges on the panel who disagree with the majority. It's a 4-3 opinion. So 3 judges think that this guy should have a case, but 4 of them say he doesn't. And the dissent points out the absurdity of paragraph 23. The food items label on the menu describes a cooking style, not a guarantee. How are these things cooked? Boneless. That's a cooking style, according to the Supreme Court. Now, the dissent called that absurd. I would concur that it is, in fact, absurd to say that boneless chicken wings is a description of how they're cooked. It's a cooking style. How do you cook? I do the boneless thing. So, paragraph 24, the dissent wonders what would happen in cases involving food that were advertised as lactose-free or gluten-free. Oh, and by the way, keep in mind that they're saying that you should be aware of the fact that there could be bones in food containing meat, right? So there could be lactose or gluten also, because obviously those things occur in food also. But the court here says, obviously such cases are not before us. But unlike the presence of the bone in this case, the presence of lactose or gluten in a food that was advertised as lactose-free or gluten-free is not something a consumer would customarily expect. What? Explain to me how I should expect bones in boneless chicken, but not gluten in gluten-free food. Again, It's not something a consumer would customarily expect or be able to guard against. And so they're actually saying that if you can expect it, you should expect it. Now, this is an idiotic ruling, but I will point out the first sentence of the dissent, who wrote, "The result in this case is another nail in the coffin of the American jury system. The majority has taken it upon itself to decide the facts of this case and has determined that there is no set of facts under which appellant Berkheimer can establish the defendant's negligence. Today, the majority declares as a matter of law that no reasonable person could consider the facts and reach that conclusion. This, of course, patently untrue, given that I and two other justices dissent from the majority's judgment." So, yes, the four justices of the Ohio Supreme Court are calling the other three unreasonable. However, what I need to talk to you about is the fact that everybody appears to have skipped over breach of warranty. Breach of warranty. And breach of warranty comes from a thing called the Uniform Commercial Code, the UCC. And I used to teach law school, and I taught for 10 years a class where we talked about UCC, specifically breach of warranty. And you have to understand there's a couple different warranties we talk about. One of them is the express warranty, 2313, Section 2-313. Express warranties by affirmation, promise, description, or sample. Express warranties by the seller are created as follows. Any description of the goods which is made part of the basis of the bargain creates an express warranty that the goods shall conform to the description. Okay? So the question I ask of you then is, how did they describe these goods? Because the food served for consumption is a good. And they said the food was boneless. Boneless. Is boneless something we can measure? Yes. Does it have a bone? No. It's boneless. Does it have a bone? Yes. It's not boneless. It's measurable. It's something we can objectively look at. Any description of the goods which is made part of the basis of the bargain creates an express warranty that the goods shall conform to the description. And by the way, it is not necessary to the creation of express warranty that the seller use formal words such as warrant or guarantee, or that he have a specific intention to make a warranty. But the fact that he says these things creates a warranty. And so it is warranted that those chicken wings are boneless. That's what that word means. Again, if you don't want to stand by it, don't use that word. Boneless. Okay? And you should also be aware that there's another warranty at issue here, the implied warranty merchantability, 2-314. A warranty that the goods shall be merchantable is implied in the contract for the sale of the seller as a merchant with respect to goods of that kind. Under this section, the serving of value of food to be consumed on the premises or elsewhere is a sale. So goods to be merchantable must be fit for the ordinary purpose for which such goods are used. So again, to eat the food and have it put you in the hospital, that's a breach of the implied warranty. So this case where the guy goes into a restaurant and eats a boneless chicken wing, there's a bone in it that puts him in the hospital. That is a breach of the implied warranty of merchantability, and it is a breach of the express warranty that the wing was boneless. And the notion that the word boneless is simply a style of cooking is idiotic, or as the dissent called it, absurd. So let me give you an example. I have right here a block of brass. This is a 2-pound block of brass. I put on Facebook Marketplace an ad that says, "Hi everybody, I got a 2-pound block of brass. I'm willing to sell you. I want money for it. How much you give me for it?" Somebody contacts me and goes, "What do you got there?" I go, "It's a 2-pound block of brass." And you say, "Okay, I'll pay you," and we strike a bargain. And you send me money and I mail it to you. And you open it up, and the first thing he goes, "Wait a second, dude, this doesn't weigh 2 pounds, it weighs 1 pound. That's wrong. I say, "Well, you should understand, things can weigh more than a pound or less than a pound. You should know that." So, no. And you go, "Number two, it's not even brass, it's copper. Let's assume that brass matters to you for some reason." And I go, "Oh, CU means copper? Well, it also says copper right here, and also says 1 pound right here. So this, instead of being a 2-pound block of brass, it's a 1-pound block of copper." And I go, "Yeah, but you should understand that metal can be copper, it can be brass, it can be bronze, it can be gold, it could be silver, it could be pot metal, it could be cast iron. So you should know that. You should know that." Case? Yes. Yes. And I'm not going to talk about whether it's fraud, misrepresentation, negligence, any of that. All it is it's a straight breach of warranty. I made 2 explicit warranties, how much it weighed and what it was. Did it weigh that? No, it weighed less. So you probably got ripped off. Was it the correct metal? No. It's the wrong metal. Boom, breach of warranty, breach of warranty. That's it. And so to sit here and talk about whether or not somebody was negligent is irrelevant when it comes to the warranty. And so I don't know how this got missed because the dissent doesn't mention it. I looked. They used the word warranty once or twice, but they did it in passing. And I'm assuming that when the attorneys who were representing the plaintiff on this, when they got the Supreme Court of Ohio, I'm hoping they argued this. But if they didn't, seriously, because right now, the state of Ohio appears to be saying that you can make statements about stuff, warranties, and you're not in breach so long as you weren't negligent. And I remember a couple of times running into an argument similar to this in court, where we'd be suing somebody over a failed repair attempt on a vehicle and saying it was a breach of warranty because it was being repaired under warranty and they failed. It's a breach of warranty. And on a couple occasions, young attorneys would actually say and go, well, we tried. We tried. And I'd say it doesn't matter if they tried. They failed. They failed. See, I get to say it twice too. Your lack of negligence isn't a defense to a breach of warranty claim. And if you think it is, I got a 2-pound block of brass to sell you. Although copper might be worth more, I don't know. It's simply the point that if you make an explicit statement about the goods and you sell them to somebody, you've got to stand by that explicit statement and understand that it might come back to haunt you. And so my question again is, if you have a menu that's got chicken wings on it, and you insert the word boneless in front of it, and now you're saying, oh, that word means nothing. It means nothing. And if anything else, it lulls the buyer into a false sense of security because they could eat it and get a chicken bone stuck in their throat. And I understand what some of you are going to say is, well, Steve, it's going to drive the cost of chicken up if we actually have to make it all boneless. Oh, maybe you should just stop calling it boneless. Well, then it won't sell as fast. Oh, this is about money, isn't it? So this is the craziest, worst decision I've seen in about a year or so from a high court. I mentioned a couple years ago that Michigan's Supreme Court made an idiotic ruling also in the lug nut case. This is actually worse. This is worse. Because in the lug nut case, they managed to gut a law called the Motor Vehicle Service and Repair Act, which I don't think is as widely used or as important as the Uniform Commercial Code section on warranties is. But that might be a judgment call. I don't know. The point is that the Ohio Supreme Court is basically saying that as long as you're not negligent, you can breach all the warranties in the world. And by the way, it won't even get to a jury, because that's what they're fighting about right here. This guy said, I want to present this to a jury and let a jury decide whether I should get paid or not. And let the other side make the argument that, oh, how it's cooked is what we mean by boneless. That describes the style of cooking. Explain to me how the word boneless is a style of cooking. Is it Cajun style? What does that mean? What does that mean? So you might ask, Steve, what do you think is really going on here? Oh, what's really going on here is you've got I'm guessing, 4 members of the court who are very, very pro-business. And to them, it's just more of a pro-business, pro-consumer thing. But I could be wrong. However, this is an idiotic, insane, absurd ruling. Okay? And, you know, I'm not a member of the Ohio State Bar, so I can say these things. But when it happened in Michigan, I called that out too. So again, just to let you know that boneless chicken wings in Ohio can contain bones. And there ain't nothing you can do about it if you're injured by one, because you should know that boneless chicken wings, of all the things they contain, it'd be bones. Why wouldn't that be the case? So says the Ohio Supreme Court. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I don't know. I'm making this up as I go.